We are back on the record. Ms. White, if you can come forward. And again, I'm taking this as allegedly. All right. Yes.
Judge, the child in this case was taken to the hospital, and there were several co-defendants. He did make allegations that the defendant in this case spanked him, hit him with a paddle, hit him on his chin. She admitted to spanking him. She said she got the paddle as a deterrent, but had never used it on him. She also admitted to spanking him with a belt 3 or 4 times. So there are admissions that she did cause an injury, and the child himself did state that she caused an injury as well.
All right. And again, I'm putting allegedly in my mind. But is there, do you want to call your client as a witness to address these issues?
I can address them, Judge, unless the court
It may be best for her because, Ms. White, what I'm looking at, and I know the state is taking it in consideration, but I have technically before me 2 violent offenses. One is the injury that was alleged to have been committed on June 22nd, 2021. And then a month later, we have this assault choking from July 15th, 2022. And so I'm trying to figure out whether or not I should grant your application. And I need more information that's not in the PSI report. So if you raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense, do you have questions?
Yes, so Kayla, if you could just explain the prosecutor's opportunity and I know that you would want to do so you can address the court especially
so during the time that Raymond was leaving my miscarriage on the case, he called both of us at Kayla. He did not discern between which and Kayla's. Raymond never discerned that it was his girlfriend to his child. And I had to explain to him, I said, do you understand that you were basically dating your step niece and you have to explain like this all to the child? We went through that bundle. We explained to Raymond and Kayla that since they decided to date each other instead of taking care of what they needed to for their own children, we were going to step back and stop as far as we would help them with a place to stay until our lease ended, and after that we were no more help to them. The last time I had spanked Alexander had been in December of the year prior, and after that I had spoken with Brandon and he said that he would check because when I did spank him, Alexander had moved and jerked, and so when he did that I stopped. I told Brandon, I said, look, if he's moving, he's jerking, I will not spank him any longer. I won't recommend you. You need to be the one to do this. You're his dad. You need to be the one that steps up. And
real quick, and just you talk about the what was said. You explain, did you ever strike Alexander?
Yes, I never struck him with the paddle. I spanked him once with my hand, once with the belt, and I never spanked him against that because he jerked both times. And my last thing was I didn't want to injure him.
And so, as you heard, Judge Boyd is talking about different cases in a certain period of time. And so, I know that you had an opportunity during the assignment week, but regarding that specific instance, it wasn't involving the kid. And so, if you could just explain to the judge briefly what transpired.
I had asked Kayla to wash the dishes that had been sitting there.
Okay, and just so both parties know, I've read the PSI report.
Very good, Judge.
Yes.
Okay, just want to make sure.
No. I always read the PSI report with a fine-tooth comb, and I've read all the police reports.
And I didn't want to be too redundant, Your Honor. I apologize.
Oh, no problem. I know, just so everybody knows, everything that's put in front of me, I always read it. Like every single line, every comma, every semicolon, I always read it. So, I still have concerns with the injury to the case, even though it's being taken in consideration. in this case. And the state is silent. But I think we need to reset this and state, if you can explain to me or have someone explain to me why that case is being taken into consideration. I don't know. Maybe it wasn't provable. I don't know. Maybe there's some other reason or some information that they have that I don't have access to, because I don't know anything about that case other than what the charge is. And I'm just a little bit concerned that we have two violent offenses so close together. So, state, will Mr. Villarreal be here tomorrow?
Yeah, Judge, he should be here tomorrow.
Okay. All right.
And Your Honor, if there was a specific time that the court one is here, I know that, and this is just me asking on her.
I know.
I know that she does work tomorrow, and I know that this is more important.
When is your next off day?
The next off day would be Wednesday.
All right. Norma, are we able to fit this in here Wednesday of next week? So let's just do a Wednesday at 9. Everyone needs to be here exactly at 9 a.m.
Very good.
Okay. All right. So we're back here for sentencing. The defendant had applied for deferred adjudication. The court, because it wasn't noted on the docketing sheet, the court reviewed the stipulations and found there was sufficient evidence to find her guilty, but deferred finding of guilt. According to the plea bargaining agreement, punishment is to be assessed at 5 years in prison. There's a $1,500 fine. State is remaining silent. They're taking in consideration 2022 CR 0841D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. And we're back here because the court had an issue with 2022 CR 0841D. So have both parties had a chance to look into that case?
Yes, ma'am.
All right, so give me information.
And I can tell you, Judge, I know we're silent, so I'm just trying to speak about factual issues.
Mm-hmm.
Is being taken into consideration in the sense that, I guess, two parts. Number one is that she has stipulated as part of stipulations to this, I believe, part of the indictment on the second case, so she's taking accountability for that portion. That's partly why. Number two is that two of the co-defendants, which is Kayla Connor and Brandon White, have taken responsibility for their part of the actions. I believe Brandon White actually went to prison because he's the main actor in that case. And then third, it was just, as you are aware, being a former prosecutor, it was made in consideration to prevent a child witness from having to testify unnecessarily when we have the same degree of offense for both cases.
All right.
And Your Honor, to speak to the case, I've spoken at length with Ms. White. I've really thought back over all the case, the other case that the court has been asking me about.
Okay, you're whispering.
I'm sorry. I've had a chance to talk to Ms. White, and I really had a chance to look over the case and think about the questions that the court asks on this. I think the conversation I had with Kayla immediately after this past week, we had a chance to kind of sit down and talk.
What's up?
I'm sorry.
Listen closely here. Kayla is trying to separate herself from the abuse allegations while admitting she still used physical punishment. And in a courtroom, those tiny wording differences matter a lot. Judges pay attention to every sentence, every hesitation, every contradiction.
Usually I try to project.
Brenda, he's lowering his voice. You remember, I know people don't listen to the radio anymore, but they used to have Secret Storm or whatever, and people have the low voice. So if you could put it up here.
Right. You know, Jed, and I think it might be my allergies. I'm susceptible to mold, so my apologies if that's what it is.
Barry White had a low voice, but you could still hear everything he was saying.
Sometimes I try to fool it.
Okay.
Doesn't always work. But to continue, Judge, whenever our conversation was really telling, Kayla's very emotional in speaking about it, and she has been in the past. So the way just to lay out the facts of the situation, she was residing in this apartment. decent-sized apartment with her husband. The COVID pandemic occurs, and Brandon White, who is the father of the child in the other case, implores them to allow him to move in there during the
Oh no, I remember the facts of the case. I'm just trying to figure out what, honestly, the taken in consideration, which has been explained by the state.
Yes, Judge, and I'll be very brief. The way that in our conversations with the state and going through it, I think Michael is spot on. That Kayla's always been willing to take responsibility for any part that she played in any of this. I think it's very clear, and the way I've explained it, and this is me advocating for her as well. She's working as she does now, lengthy hours, and when she's home, most of the time she's sleeping. In talking to her, it's very clear in this case that Brandon White, the individual's, Alex's father, the child's father, essentially had the most interaction with the child. And he lived sort of a secretive life. I don't know if secretive is even the right word to put there. They lived their lives, and Kayla, to the degree that possible, continued to try to live hers. But when you talk to her about it, and I've related this to the state, that does she wish she was more perfect? Does she wish that she could have done, looking back on it, could have maybe done more or done those things? Yes, of course. I think everyone wishes they were perfect on things. But I truly believe, Your Honor, that she thought she was doing best, that she was trying to play her role, and that she trusted that that the child's parent, would be taking care of things in a responsible manner. Having a chance to look at the case in total, to look at Kayla White's role and everything, and what could have been done. I do not believe that I personally do not believe that she is guilty of committing any abuse or violence toward Alex. But again, that's part of the conversation that we were having here, is that I think that when you look at the roles that were played here, Kayla White's role, while she will be the first to admit she could have done maybe more, was not the one that was resulting in the injury to the child. And so I think for those reasons, Judge.
I'm sorry, just one moment, that interruption. That was a medical call. All right.
May I proceed?
Yes.
And so looking at the case and looking at the situation with Ms. Connor.
This is one of the most important legal moments in the hearing. The prosecution is basically explaining why they agreed to take another serious case into consideration instead of forcing a child victim to testify in court. That's a huge factor in plea negotiations, especially in emotionally charged family violence cases.
Everything, the letters that I presented to the court last week, I think the picture that is painted is one that I believe of her that is within my sense of her, which is that she's always going to do her best. She wants to do her best, always. Will she make mistakes in life? Absolutely. But she's the type of person that will do whatever she can to make amends for those, to do better for herself, for her family, for her community. And I think that in the court's mercy, should she be provided and allowed to do a deferred adjudication, community supervision, the court will see that she will attend all of her appointments, do what is asked of her, not just the bare minimum, but beyond that. That's the person that I know her to be. And I think that's the reason why we're here today in this specific situation.
All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God? All right, you're going to have to speak up.
Yes, ma'am.
All right, could you state your name for the record?
Kayla White.
All right, where are you living?
I am currently living at 5711 Cuba Road in Seguin, Texas with my general manager and her mother.
All right, are there any children in that home?
No.
All right, where's your husband?
He's living with a friend as far as I know of. I don't know which friend and I don't know where.
Are you all still together?
We are still married.
But no, are you still together? Are you still in contact?
No.
What's his name?
Christopher White.
You can actually hear the defense trying to humanize Kayla here, portray her as overwhelmed, emotional, and trapped inside a chaotic situation rather than being the main aggressor. But the real question is, does responsibility disappear just because someone else was worse?
So is she asking that her probation be transferred to Seguin, or would she be staying in Bear County?
Either way is fine with me. If it's in
No.
San Antonio, I'll take it.
No, let's not do the either way.
It would be Seguin, Judge. I think about just knowing these things, I think it would probably be best.
So are you asking that your probation be transferred to Seguin?
Yes, Your Honor.
Probation, is that possible?
Your Honor, it won't be transferred from that account. It will still be supervised here.
Okay. All right, the court will follow your plea bargaining agreement. There's a $1,500 fine. That will be probated. 5 years deferred adjudication. Take in consideration 2022 CR 0841D. There's to be no contact with the following persons: Christopher White, Alexander White, Kayla Connor. There's to be proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Defendant is not allowed to reside in any household with minors. There's to be no unsupervised contact with minors. There's an affirmative finding of family violence.
And this is the defense's final gamble. They're not arguing perfection anymore. They're arguing potential, basically telling the judge, she made mistakes, but she's still salvageable. In sentencing hearings, that emotional distinction can literally decide whether someone walks free or goes to prison.
There's to be regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Negative, except for my medications that I'm currently taking.
What medications?
It is a generic Lexapro. I can't pronounce it. It's Calipram or something like that. And I also take Trazodone for sleeping, but I haven't taken it in a week because I haven't been too exhausted.
All right, what are you on those medications for?
Trazodone for sleeping because I have severe insomnia, and the generic Lexapro for my bipolar disorder.
All right. I'm going to ask for a MIC.
Notice how calm the courtroom gets right before the judge questions Kayla directly. These moments are incredibly dangerous for defendants because the judge is no longer evaluating paperwork. She's evaluating the person standing in front of her. One bad answer can destroy an entire plea deal.
Evaluation. And the defendant, you're going to have to sign a release so that the probation can have access to any of the medications and doctor's reports. There's to be regular UAs, field visits, one time per month, random, and that's until further notice. State, it's not listed in here. Are you all requesting any type of classes? Because there's not a BIP class listed or anger management.
I think it's because we were silent, Judge. We didn't make any.
Okay, thank you. All right. The BIPP course. All right. And State, I know you're silent, but now that you know there's the court is granting her application, is there any condition that you think would be helpful to her?
Not that I could think of, Judge, other than Christopher White is a fugitive from his court.
Mhm.
So I hope that if she does not have that information, but if she does, that she pass that on to law enforcement so that he can be brought to court to face the charge. He's a co-defendant on this case.
Okay. All right. You realize you're not to have any contact with Christopher White. That means not by phone. That means not in person. That means not by card, not by any type of signals. You understand? If you end up having contact with him, that's going to be a violation of your probation. A motion to revoke will be filed, and you could be looking up to 10 years in prison. Do you understand? Probation, is there anything else that she needs? Probation, is there anything else she needs?
No.
Is there anything else you need from the court in order to be successful?
No.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because there is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Remain in the courtroom. Probation will go over conditions with you.